A group of some of the country's most skilled legal minds are calling on the Victorian Parliament to reject the latest bid for power from the Premier Daniel Andrews. The Victorian Government's COVID-19 Omnibus, Emergency Measures and Other Acts Amendment Bill 2020, was rushed through the state's Legislative Assembly, or the lower house, last week. Today, in a highly unusual move, 18 judges and QCs, as I said, have signed a letter against the bill, concerned that it endangers the freedoms of Victorians. Mr Stuart QC is one of those calling for change, wanting this bill to be withdrawn from the Parliament. He joins me now from Melbourne. Thank you for your time, Mr Wood. Let me quote from the letter you signed for my viewers at home. You signed it with 17 other very senior legal representatives from Melbourne, authorising citizens, this is the letter, to detain their fellow citizens on the basis of a belief that the detained person is unlikely to comply with directions by the authorised citizens, is unprecedented, excessive and open to abuse. Now, this is very strong language. Why have you spoken out?
Well, obviously, I can't speak on behalf of the 17 other signatories, Peter, and I wouldn't presume to speak on behalf of the eminent ex-judges who also signed the letter, and many of the others represent a full spectrum of political opinion. But the thing that unites us all are the two things you mentioned in your quote that you just read out. First, this bill attempts to empower unqualified, untrained citizens. And secondly, it empowers these unqualified, untrained citizens with the draconian power, draconian ability to detain fellow citizens. I mean, it is extraordinary. Normally, that sort of power is vested only in skilled and trained and qualified personnel like the police force, people who are subject to a whole raft of rules and regulations. Yet here, these time-honoured principles have been thrown out, and in its place there is this idea that some unqualified, untrained citizen should have the power of detention over fellow citizens.
Of course, the Parliament not long ago extended the state of emergency powers for the Premier. There was obviously state of disaster powers also provided in this pandemic. But this is something completely new. I don't think I've seen it in any other jurisdiction in Australia. Have you seen anything like this before?
No, it's extraordinary. You got to remember the context here, Peter, as you've alluded to. We've got in the chain of command, we've got a health minister that refuses to answer questions of the Parliament. We've got a mid-level health bureaucrat who's making sweeping statewide edicts. And now we propose to enforce those edicts with unqualified, untrained citizens who are given the power to detain fellow citizens. I mean, this is why the signatories to the letter described it as unprecedented, as excessive and open to abuse.
And suppose this bill passes the Parliament. I mean, it's passed the lower house. We know it's headed to the upper house. What recourse is left to citizens who might feel that their liberties are being taken away from them here?
Well, there's not a lot you can do once the law comes into operation. The best you can do at the moment is to try to ensure that this law does not make it to the statute book, so that we are not faced with the problem of untrained, unqualified citizens abusing the power to detain fellow citizens. There are already problems, criticisms made of the police with all their training, with all their expertise, subject to all their rules and regulations about their selective enforcement of these directions. That's going to be doubly or triply the case when it comes to people who are completely unqualified and untrained. And it's just something that the Parliament shouldn't countenance.
You know, when governments seek extraordinary powers for extraordinary times, in times of crisis, I always believe that's when you need the greatest scrutiny on the legislation, not the least scrutiny on the legislation. And I think until this group of 18 lawyers and former judges came out, and I accept your point, this is not a political statement from you or anybody, this is all about what's contained in the legislation. Most Victorians wouldn't have had it drawn to their attention.
Yeah, well, it was obviously very important that this further development in the current arrangements that are confronting the state of Victoria is brought to everyone's attention. I mean, no one here is suggesting that there shouldn't be an enforcement regime for people who have COVID and their close contacts, that they shouldn't be in quarantine. The issue is the method of enforcement. And the reason that has been given in the letter for the 18 signatories to speak out is that the method of enforcement is excessive and open to abuse. It shouldn't be in the hands of unqualified, untrained citizens, and they shouldn't have the draconian power to detain other citizens. And
Stuart, I will leave it there, but we will watch this closely.
Thanks, Peter.
Thank you for your time.